Good morning, class. This morning we're going to start with the second part of our study of the law on obligations and contracts. It's covered by Title 2 of the Civil Code, Contracts. We start today with Chapter 1. Chapter 1 deals with the general provisions. It starts with Article 1305. 1305 states that a contract is a meeting of mind between two or more persons whereby one binds himself with respect to the other to give something or to render some service. So, contract is the meeting of minds. When two parties agree that one party will give something or the other party will render service in exchange for something, then the life of the contract begins. What are the essential elements of the contract? The first element is consent of the contracting parties. So consent, the second is an object certain, which is the subject matter of the contract, and third is the cause of the obligation, which is it is established. So simply stated, the essential elements of the contract are consent, object, and cost. What are the different classifications of contract? First, according to their relation to other contracts, you have preparatory, then you have principal, then you have accessory. What are preparatory contracts? Very important ang distinction itong mga few items na i-discuss ko, class, on the classifications of contracts. Preparatory contracts are those which have for their object the establishment of a condition in law which is necessary as a preliminary step towards the celebration of another subsequent contract. So, siya yung preparatory, like let's say, you are abroad, no? And you want to enter into a contract in the Philippines while you are absent, so you will be leaving a, let us say, an authorization, no? An authorization or a special power of attorney in a favor of somebody, no? Who will enter into a transaction for and on your behalf. You call that one a contract of agency wherein the attorney in fact is your agent. So, pwede siyang pumasok sa transaction. Therefore, a contract of agency is a preparatory contract. Also, the contract of partnership. The contract of partnership is a preparatory contract. Preparatory to what? Preparatory to the operation of a business in order to earn profit. So that is the first distinction according to the relation to other contract. Another one is principal. When you say principal, you don't need a preparatory contract in order to enter into the transaction. Like let's say you want to enter into a contract of sale, ikaw mismo ang papasok sa contract of sale. So those which can subsist independently from the other contracts and whose purpose can be fulfilled by in themselves. Then you have accessory contract. What are these accessory contracts? Pandagdag doon sa main contract. Like let's say may utang ka, no? In order for the creditor to be secured, you have to execute a contract of mortgage. Isasanla mo sa kanya ang isang bagay para ma-secure ang payment mo. No? Just in case hindi ka magbayad, then yung sinanla mo sa kanya, i-foreclose niya yun. No? I-foreclose niya. Okay? So, a contract of pledge or a contract of mortgage is an accessory contract. Second cluster, no? The first cluster kanina is according to the relation to other contracts. You have preparatory, principal, and accessory. Now, second cluster, according to their perfection, you have consensual and legal contracts. When you say consensual contracts, contracts which are perfected by consent, no? Perfected by mere consent, while real contracts are perfected by the delivery of a thing, no? Then you also have, according to their form, you have common and you have special. When you say common, those are which do not require a particular form, no? While in special format, those which require a particular form. Remember our lesson on condonation? Di ba sabi doon, it should comply with the format or the rules of donation. So the contract of donation falls under special or formal contract. That is the third cluster according to form. You have common and special. Common, walang form required, while special, merong form required. Okay? So, you also have according to purpose, according to subject matter, according to vinculum in which they are produced. No? Sa vinculum in which they produce, you have unilateral, one party, no? One party offers to another, no? And the other one is bilateral, within gives rise upon the one which give rise to reciprocal obligations for both parties. So contract of sale is a bilateral contract. I give you this property, you give me your money. Na? So that is a bilateral contract. Na? Seventh cluster is according to their cost. You have onerous and gratuitous. When you say onerous, something is expected in return. I give that you may give. Na? Dito naman sa gratuitous, I give out of my love and affection. Na? So nothing is expected in return. According to their cost, you have onerous and gratuitous. Then according to the risk involved, you have commutative and aleatory. What is a commutative contract? Those which each of the parties acquire an equivalent of his prestation of such equivalent in pecuniary appreciable and readily determined from the moment of the celebration of the contract. In a contract of partnership class, which is commutative, when one party contributes a house and the other party contributes money, under the presumption that their contribution is equal, let's say ang money na kinontribute niya is 1 million, the presumption there is that ang value ng house is also 1 million. That is commutative. Then you have aleatory. What is an aleatory contract? One which the liability depends upon the happening of a certain event. Like let us say contract of insurance. You pay your premium. If something happens, then the liability of the insurance company attaches. Okay? So that is according to the risk involved. You have commutative and you have aleatory. According to their names, we have nominate and innominate. Nominate contracts are contracts which has names, no? Like let's say contract of sale. Innominate contracts are contracts which have no name, which we're going to discuss later. Now, in chapter 1, the contract of adhesion is discussed there. What is this contract of adhesion? A contract of adhesion is a prepared contract wherein one party prepares the terms and conditions and the other party merely adheres to the provisions of the contract. No? Like let us say, sumakay ka sa eroplano. No? Pagsakay mo sa eroplano, nagpirma ka ng parang kontrata sa manifesto. Pirma ka lang diretso. No? You call that one the contract of adhesion. Or let us say you bought a condominium unit. Sa condominium unit, ipipresent sa iyo ang deed of sale. Nakaprepare na, maliliit ang titik niyan. All you have to do is to sign. No? That is a sample also of a contract of adhesion wherein the condominium company determines the terms and conditions of your agreement. And if you want to stay there, if you want to buy their unit, then you have no choice but to agree. That is contract of adhesion. Okay? Now, one important principle in contract is the principle of autonomy. Okay? So I repeat, first principle in contract is the principle of autonomy. What is this principle of autonomy that is covered by Article 1306? The contracting parties may establish such terms, stipulations, and clauses which may deem convenient provided they are not contrary to law, morals, good customs, public order, public policy, and the like. Okay, at the onset in our discussion in, I think, Chapter 1, Chapter 1 of the Rules on Obligation, one source of obligation is contract, di ba? Contract, diniscuss natin doon that parties may stipulate whatever they want in their contract so long as it is not contrary to law, morals, good customs, public order, and public policy. And between and among the contracting parties that will serve as a law between and among them. No? You call that principle the principle of autonomy to contract. So that is the first principle that you have to remember in contracts. Okay? The second principle is mutuality principle, and that is covered by Article 1308. What is this mutuality principle? The contract must bind both contracting parties. Its validity or compliance cannot be left the will of one of them. Ibig sabihin, both parties should agree. Pero sir, paano yung sa contract of adhesion? The fact that you have a fixed signature in a contract of adhesion, the presumption there is that you have agreed with the terms and condition. You call that one the principle of mutuality, where the contract must bind both contracting parties. Its validity or compliance cannot be left to any one of them. So the first principle is autonomy to contract. What is that autonomy to contract? You may stipulate whatever terms you like, to put in a contract so long as it is not contrary to law, public order, public policy, morals, good customs, and traditions. The second principle is mutuality principle. What is mutuality principle? The contract binds the contracting parties, their heirs, and their assigns. and its validity or compliance cannot be left to one of the contracting party only. Okay, that is the second principle. Third principle is relativity of contract. What is this relativity of contract that is covered by Article 1311? Let us read. Contracts takes effect, no? Contracts takes effect only between the parties, their assigns, and their heirs, except in case where the rights and obligation arising from the contract are not transmissible. So if the rights are transmissible, the contract binds the parties, their assigns, and their heirs. If the contract are not transmissible by their nature or by the stipulation or any provision of the law, the heir is not liable beyond the value of the property received from the decedent. What is meant by the last sentence, the heir is not liable beyond the value of property he received from the decedent? Ang asset na papamana, the answer is yes. Ang liability na papamana, depende. Na? To the extent of the value of the inheritance, you are liable. But beyond that, you are not liable. Let us say, parents mo, mayaman. No? Kaya lang marami palang utang. No? They were cold. Tinawag sila ni Lord. No? So ikaw ang natira ngayon. Obligated ka ba na bayaran ang utang nila? To the extent of the value of your inheritance, yes. But in excess of that, you are no longer bound to pay. You are no longer required to pay. Like let's say, asset of the parents, 5 million. Liability is 8 million. Magkano ang pwedeng singilin ng creditor sa iyo as an heir? 5 million lang. The 3 million, they could not no longer collect that from you. Okay? Because the extent of the value of your inheritance is only 5 million. You call that one the relativity to contract, no? Okay, now let us go on to the discussion on relativity to contract is the second paragraph, no? Second paragraph of Article 1311. If the contract should contain some stipulation in favor of a third person, he may demand its fulfillment provided he communicated his acceptance to the obligor before its revocation. A mere incidental benefit or interest of a person is not sufficient. The contracting parties must have clearly, deliberately conferred a favor upon third person. What do you call that right wherein a party that is not included in the contract, may benefit siya na makukuha, no? What do you call that stipulation? We call the stipulation pour out 3, no? What is stipulation pour out 3? This is an agreement by two parties which will benefit a third party. And that is covered by the second paragraph of the article that I have just read, no? Article 1311. Now, for stipulation pour out 3 to ensue, no, there is a need for us to have this. No? Number 1, there must be a stipulation in favor of the third person. Number 2, the stipulation must be part and not the whole of the contract. Number 3, the contracting parties must have clearly and deliberately conferred favor upon a third person and not merely an incidental benefit or interest. And number 4, persons have communicated his acceptance to the obligor before its revocation. And number 5, neither of the contracting parties bear the legal representation or authorization of a third party. So simply stated, when you say stipulation pour out 3, it is a stipulation in favor of a third person. To prove whether there is a stipulation in favor of the third person, you go back to the requisites. Okay? Clear tayo dyan, class, ha? No? That is stipulation pour out 3, the stipulation in favor of a third person. Okay, now, let us go to nominate and innominate contracts. Now, one of the classification of contract kanina is nominate and innominate contract, that is according to the names or norms regulating them. Now, when you say nominate contract, these are contracts which has names, no? Like let's say contract of sale, contract of lease. Like ako, empleyado ako, no? Empleyado ako, what I entered into is a contract of employment, no? Or sometimes I buy a property, I enter into a contract of sale. So, the title of the transaction that I have entered into is designated. You call that one nominate. Now, what is this innominate contract? Ang innominate contracts, class, ito yung contracts na walang pangalan, no? Pero by its term, no, lack the individuality and are not regulated by special law. But by its term, by its term, judicially ano siya, yung juridical necessity